Namaste, everyone. Good morning and welcome to Vishwa Talks. My name is Srivani. Thank you, each one of you, for attending today's events. For those of you, a very warm welcome to you. And for those of you who are joining us for the first time, here's a little bit about us. Vishwa Talks is an initiative by Vishwa. Vishwa is an online platform for everyday change makers and social champions. It's a crowdfunding and a crowdsourcing platform that is aimed at helping anyone find the effort they need in their efforts to solve problems for themselves or for others. And in the process, allow us to make our world into a better place. Vishwa Talks are a series of weekly webinars hosted every Saturday that are focused on gaining an in-depth knowledge from the experts on a wide range of topics that are pertinent to our current context. Our speaker today is Deepika Kihal. She's a senior resident fellow and leads the judicial reforms at Vidhi. She's currently managing multiple independent and engaged projects which explore the intersection of law and policy with other disciplines such as technology, design, management, etc. She is working towards making the JALDI, justice, access, and lowering delays in India, a mission. At Vidhi, a multidisciplinary, collaborative, innovative hub for judicial reforms. Deepika is currently a part of the experts group set up by the Supreme Court's E-Committee to envision E-Court's Phase 3 project. Her work at Vidhi across the years has focused on studying court management systems across different levels of judicial hierarchy, with specific attention on tackling government litigation across these levels. She regularly writes in leading prints and online media on issues concerning judiciary, women, and children. Also collaborates with other CSOs in conducting legal awareness camps and has conducted gender sensitization and legal trainings in police department in Karnataka. She graduated from NLSIU Bangalore in 2012. Since then, she has worked at CAM, real estate and capital markets, and Dua litigation team. Before joining, she is a trained Carnatic singer with a brief stint at the All India Radio and Kannada movies. Before we get started, I'd like to mention that our speaker will take questions from you after her main talk. So please raise a hand or type in your questions in the chat. Now, if I may invite our speaker to please start today's Vishwa Talks.
Hi, good morning, everyone. It's a pleasure to be here. Thank you all so much for taking time out on a Saturday morning. I don't know where you all are joining from, but weekend curfew has been lifted. So I'm surprised to see all of you still at home attending a lecture, but I will try to make it as non-boring as possible. Srivani, thank you so much for the kind introduction. Let me share my slide deck to begin with. I hope this is visible. Srivani, is it visible?
Yes, ma'am.
Okay, thank you. All right. I'm here to speak to you all about a slightly niche topic, something that is taking shape in India, especially only now. So I do think in terms of timings, we are at an interesting phase where this topic is even something that we can discuss. So we are here today to talk about what it takes to change the justice delivery systems to truly enable access to justice for all? How can we all as outsiders to the court system, the public court system, assist it in improving itself and meeting the ultimate constitutional goal that it has set for itself, which is to ensure justice for all? Policy making typically is seen in the context of the executive or the legislature. But when it comes to the third pillar of democracy, which is the judiciary, typically we don't really talk about judicial policy making, especially as an outsider. However, now that is changing, and thankfully it is, because we all know the state of affairs the judiciary has been in over the last few decades. Now, before unpacking what policy making for the judiciary is and where we are at in that journey, let us try and see and understand what really access to justice means. We all may know that there is, sustainable development goals that the world has set for itself under the aegis of UN. The SDG, Sustainable Development Goal 16, talks about enabling access to justice for all and building accountable and inclusive institutions. So clearly, access to justice is a phrase which is fairly popular in India and across the world. This is something that we talk about in almost our regular conversation, right? If anyone has had any interaction with the legal system, and by this, I don't mean just the courts, be it the police, be it any form of state authority, we do talk about how there is a need for access and ultimately there is a need for just outcomes. But what does this really mean? Even within our own constitution, we all are aware of Article 14, which talks about right to equality. But within that also, a key component is equality before the law and equal protection of the law. That is what equality under Article 14 means, that you are always, as a citizen of the country or as a person residing in the country, have equal protection of the law. And if you do go to the court, then all of you are considered to be on an equal platform. No one person is treated at a better level than the other. That is encapsulated within the concept of justice as envisaged under the Constitution itself. Apart from Article 14, we also have Article 39A, which specifically talks about ensuring that there is legal aid, ensuring that there is access to justice for all through representation of lawyers. All in all, the phrase access to justice is something that we hear about quite often, we speak about quite often. It is there in some of the most important texts, such as the Constitution, such as the UN Manifesto, now the Sustainable Development Goals. But what is it really? What does it entail? If access to justice becomes a reality, what does it mean for ordinary citizens such as you and me? The first part of this phrase is access, right? Now, access, does it mean just physical access to courts? So say in your city, in your village, in your taluka, there is a court complex. Does access mean that you have something physically present that you can enter into physically? Is that enough? If we just have physical court complexes within the vicinity of various jurisdictions, is that enough of an access? Or does access actually mean something more? Does it have to do with the quality of people who are there in that court complex? Okay, you have a physical structure, but who are the judges who are sitting there delivering justice? Who are the court staff, and how empathetic are they to your problems? You interact with courts only when you have a problem, right? There is a popular saying that you need to avoid doctors, police, lawyers, and courts as much as you can throughout your life. That is a popular saying, and there is a reason for that, because if you are interacting with any of these authorities or any of these institutions, that means you have a problem, right? So when you enter such a system with a problem, how is the institution, how is the system, how are the actors within the system dealing with your problem? The quality of service over there, should that be a part of access as well? So it is not just the physical court complex, it is physical court complex plus the quality of service that is available in that court complex. And this is applicable to all the actors within that institution, from judges to court staff to the lawyers that you interact with. All of them, how are they making your experience of seeking justice? Is your experience good? Is your experience in a way that you come out almost more miserable than when you entered the system? These are all parameters under the term access. So it is not just the brick and mortar building. It is equally to do with the personnel who are part of that system. Then when it comes to access to justice, is it just about the outcome? Are we looking at only the ultimate result of the case, in the sense that you go and file a case against perhaps your neighbor? Is your sense of justice only to do with whether the case was decided in your favor? If the case is decided in your favor, then are you happy with the overall experience? Even if it has taken you 5 to 6 years to get that result, even if it has taken you multiple visits to the court, even if it has taken you multiple lawyers to get to the ultimate justice, right? So it is not just about the final result. And people who have had the unfortunate experience of interacting with Indian courts will know that it is very little to do with the final result. It is a lot to do with the process itself. And the way the Indian judiciary, unfortunately, is currently functioning, the process itself has come to be a form of punishment. Most often, cases are entering the court system and the parties are reaching the doorsteps of court only because they know that it is going to take at least 5 to 6 years for there to be any final outcome. And they want to drag on the case as a form of punishment to the opposite party. On the other hand, if you're actually there with a genuine grievance and it takes you 5 to 6 years to get anything. So if for instance, there is a check bounce case and you file a case against the person who has done you wrong, and if it takes you around 5 years to get back your money worth 1 lakh rupees, you have already spent so much time, so much money, that at the end of it, even if you were to get that 1 lakh rupees with interest, it becomes meaningless, right? So that is not the kind of justice we are talking about. So it is not the final outcome. It is as much to do with the process. And at each stage of it, what has been your experience? So what has been the cost in terms of money and time that you have had to suffer to get justice from our justice delivery system? And my focus today is going to be on public court system, that is the courts as service providers of justice. But when it comes to dispute resolution, it is not just the courts that are capable of delivering justice. Right now, there are several other avenues to seek justice. There is mediation, arbitration. Now there is something else also called online dispute resolution platforms. So the avenues for resolving disputes and seeking justice are diversifying. But for today, I will be focusing on how the courts are structured and how capable are they of delivering justice. And given that we all know that they are not, what can be done about it? What can be done about it, and how much progress has already been made in the last few years in reforming our justice system? Before we go into that, I thought I'll spend a couple of minutes on explaining the structure of the court system itself. And I'm sure all of us are vaguely familiar with this structure. In our civics book, at least, we've all read how there is a federal executive, but we have a unified judiciary, right? What does that really mean? Unified judiciary, that principle is applicable when it comes to the judicial hierarchy, in the sense of where the courts are looking at justice delivery as a form of as their work. We are talking about that aspect of the court system to say that it is unified. We have the district courts at the bottommost tier, then we have the high courts, and then we have the Supreme Court. This is the rough hierarchy when it comes to the judicial side of things. And even within the district judiciary, we know that there are multiple layers. We start with the municip courts, where we have civil judge junior division, then we go to taluka level courts, and then we finally have district court, which is the highest tier within the district judiciary. And these district courts are there in each and every district. So although there are 3 top level tiers, even within the district courts, there are multiple layers. And why do we call it unified? It is because when it comes to the judicial side, what the Supreme Court decides is binding on all the remaining courts within the country. We follow a precedent-based system, which means that whenever the Supreme Court has decided on any particular issue, that decision, that stance taken by the court on a particular question of law becomes binding for all similar cases in the future. So the decision itself is binding on all the courts, and the stance as well serves as a precedent for future such issues. Because of this hierarchy, which is that whatever Supreme Court decides is applicable to the High Court and the district courts, we identify this as a unified structure on the judicial side. And whatever the High Courts decide become binding within the High Court. As we know, there are high courts in each state. Right now, we have 25 high courts, and some of the high courts have jurisdiction over union territories and multiple states. So right now, we have 25 high courts, and those high courts, the decision taken over there on the judicial side is binding on courts below them. So all the district courts in a particular state follow the decisions that have been made by the high court of that particular state. While this is the status of things on the judicial side, on the administrative side, it is quite different. On the administrative side, the Supreme Court is not really supreme. The way the Constitution talks about administrative hierarchy is that the high courts are their own masters. They are not bound by what the Supreme Court decides in terms of policies and rules. This is because, as we know, policy making is best done at a local level, right? Top-down approach when it comes to central government or the central legislature, we have seen it doesn't really make sense because the local conditions are quite different, especially in a country like India with so much diversity and so much disparity. What works in Delhi doesn't work in Bangalore, and what works in Bangalore doesn't work perhaps in Koppal. Right? So each jurisdiction has its own sets of challenges and advantages. Hence, policy making is best left to a more localized unit. Keeping this in mind, the way the administrative hierarchy, and on the side of administration, we deal with policy level issues, right? So this is dealt with at the Supreme Court level separately and at the High Court's level separately. Decisions taken by the High Court, however, is binding on the district courts as well. This is what is the lay of the land when it comes to administration. The Supreme Court has its own sets of policies applicable to it to deal with issues concerning its administration, and the High Court has its own sets of policies. However, increasingly, the Supreme Court is sort of employing a soft touch method when it comes to influencing the policies at the High Court level. And this is seen as its way of ensuring that there is some level of uniformity and continuity in policies across all tiers of the judiciary. We don't want the Supreme Court, for instance, to be saying that there will be virtual courts in all its hearings, while the High Court saying that no, only physical form of courts will function. So this sort of disjunction is not good for the entire structure to function seamlessly. Therefore, to an extent now, the Supreme Court is also influencing the policies at the High Court level and thereby the District Court level. So to quickly summarize, we have a unified structure when it comes to the judicial side, where we follow precedent-based system, where the Supreme Court lays down the precedent and the rest, and it becomes binding on the high courts. And also appeals go from the District Court to the High Court and the Supreme Court, and whatever is decided by the Supreme Court is the final decision. Beyond that, there is no appeal. So it automatically brings the case to finality. That is on the judicial side. And on the administrative side, high courts are their own masters when it comes to administration, but Supreme Court is now employing a soft touch policy. And broadly, we also know that courts employ multiple jurisdictions, that is like civil jurisdiction and criminal jurisdiction. Civil cases are those that deal with your civil disputes, while criminal cases involve the state looking at a crime and seeking to punish the culprit. And this is based on the state being a welfare state. So it is not between two individual parties that criminal cases are fought. Criminal case is typically between the state versus the accused person. This is broadly how the judiciary is structured. Now, what is judicial administration? As I mentioned, when it comes to the judicial side of things, we are looking at mostly the judges, right? So the judges sit there, they have, there's a bunch of cases that they are dealing with, varieties of disputes, civil disputes and criminal cases. There are multiple issues, as we may have encountered and we may have read about. We talk about the quality of judgments. We debate about whether this judgment was right or wrong, what could have been done differently while granting a bail, or if the judge sitting over there is well trained, does he have enough avenues to do better research to ensure that the cases are decided in a correct manner. All of these are issues that are on the judicial side of things. How is a judge dealing with her set of cases? What decisions is she making? And whether the High Court is upholding the decision of the District Court, or whether the Supreme Court is upholding and agreeing with the decision of the High Court, all of that, those are the issues on the judicial side of things. But on the administrative side of things, judiciary is essentially a system. It is an institution just like any other government office or any other company, a large company with complex set of functions, multiple employees serving under different branches. So it is a huge machinery which is constantly working in the background, which forms the judiciary. However, as an outsider, what we see is just what the judge decides on his or her cases, and that is what becomes part of the popular narrative. Very little attention is paid to what is happening in the background. And this background is what makes the judiciary function or break down. And that is what we are going to be looking at today. What is judicial administration? Who is looking at what cases comes up before the court? How are cases listed in a daily basis? How are dates allocated for your cases? We all know, this famous dialogue by Sunny Deol and Damini. I think that was the movie Tariq Pe Tariq. That has become like a way to identify the status of things within the judiciary. We know that adjournments are where cases are listed for next dates without there being any progress on a day-to-day basis. So adjournments are rampant in our judiciary. Cases take years on end to get resolved, or even to move from one stage to the next stage. Why is this happening, right? Is the judge sitting over there to be blamed? Is she the only person to be blamed? Or is there something happening behind the scenes which needs fixing? And as I said, the judiciary removing the entire aura associated with a judge, the kind of respect they command, the sort of authority they command, and the entire noble profession tag attached to the legal profession. Remove all that paraphernalia. Ultimately, you have a system, you have an office which needs to run smoothly to ultimately deliver justice as a service. So we need to sort of de-link all these noble ideas from the judiciary as a system for us to really be able to identify where the problem lies. Otherwise, it becomes like one, I don't know, we are, as in either we are extremely critical of the judiciary or we worship the judiciary as an equivalent of a temple or a mosque or a church. Neither of this is going to help the judiciary function better. So a correct way to approach this is to see judiciary as a gigantic institution with complex set of functions, and we need to dissect each and every function to see where the problems lie. On the right hand side, you will see different branches that exist within the judicial administration. We have filing branch, and this is where cases enter the justice system, right? You need to file a case as a starting point. And that is handled by filing branch officials. There is a separate set of administrative staff dealing with just the filing. And filing is not that easy because you need to file the correct set of documents. You need to see if they are in order. You need to assign a registration number, and then you need to identify which judge it will go before. And that system is something that is quite ad hoc. Who is it going to go before for today's set of cases, for this category of cases, for this nature of disputes? So there is a lot of permutation and combination of factors that are considered by the filing branch for your case to proceed from that stage to the next stage where it will be taken up by a sitting judge of a court. Now, after filing branch, once the case enters the court system and is registered, it goes before a judge, as we all know. Until the case is disposed, this file, your case file, physical case file, remains in what is called the pending branch. That is because your case is now pending with the judiciary. If your case takes 2 years to get decided, or 5 years or 10 years to get decided, the pending branch is in charge of ensuring that your case file is maintained in a way that it assists the judge and it assists the lawyers and you to proceed with the case in a systematic manner. So there is a huge responsibility with the pending branch, and with the lakhs of cases that enter the justice system, you can see how the pending branch is almost always clogged. There are lots of case files that they need to manage and arrange systematically and ensure that as and when your case gets listed before the court, they take the correct file and submit it before the court for hearing. There cannot be any mix-up. Then you have your judges support staff and you have your data room. By judges support staff, I mean the stenographers, the bench clerks, the shirastidars, the copiers, registrars, all of them are there to just support the judge to ensure that she does her work in an organized and in a timely manner. Then there is data room, which, given that now there is infusion of technology in the way the court functions, we need a data room where the case file details are entered into the digital repository. We have had eCourts project, which is a project to introduce and integrate technology in the functioning of the judiciary at all its levels. Phase 1 of the eCourts project and phase 2 of the eCourts project have ensured that there is physical infrastructure which allows the administrative staff and the judges to use technology. So we have laptops, printers, internet connectivity, all of that already available in all our courts, in almost all our court complexes now. And to manage data that is coming from this entire case management system now, we have a data room where we have data entry operators converting the data from its physical form to digital form. Then you have your record room where all the cases that are disposed, the files, the physical files are then stored in the record room for a fixed number of years. And why does it need to be stored? Because we know that there is an appellate system. Today you have your decision with you, but at the district court level, your case may be over, but one of the parties may appeal in the high court. So that case file, when there is an appeal, moves to the high court. Until that happens, these case files are stored in the record room. And you can imagine, like, layers and layers of case files for the last 10, 20 years are stored in these record rooms. And there are personnel, there is like physical staff managing this specific requirement. And then you have your administrative committees. Now, these administrative committees are typically there at the level of high court, where judges are identified to take care of different issues concerning the judiciary on the administrative side. And this ranges from your infrastructure, court infrastructure. Is the building constructed properly? Does the washroom have running water? Are there judges' chambers which are well maintained? Are the equipments working properly? Are the corridors clean? So court infrastructure committees, which are actually chaired by judges, looks into all of these issues as well. And this is what is anomalous when it comes to judicial administration. All of us as outsiders typically identify judges as people who are sitting there deciding cases. However, the same judge, after she retires from the court room duty, she's sitting there from morning till evening handling cases. But once she moves to her chambers, she is not just a judge. She is also in charge of multiple administrative responsibilities. She is looking at her own courtroom, and if she is part of her own courtroom in terms of seeing if the cases are getting listed properly, if the files are arriving to her courtroom properly, how many cases need to be listed the next day, all these administrative decisions, she herself is taking a call on that. Equally, if she is part of these administrative committees, say with respect to infrastructure, with respect to technology, or with respect to staff maintenance and staff recruitment, she is equally spending her time creating policies, creating rules, sitting in interviews, or looking at court infrastructure, taking a survey. She is interacting with the vendors, with people who actually provide the service of maintenance and equipment. So a judge is not just discharging judicial duty, she is equally looking at administration. In the Indian context, this becomes extremely problematic because, as we know, the judge is already overburdened, right? This slide will tell you the kind of burden I'm talking about. We know these top level problems within the judiciary. We know there is massive pendency. In the district judiciary, we have around 4 crore cases pending. And we have around 19,000 judges at the district judiciary. 19,000 judges today are dealing with 4 crore cases. At the high court level, we have 56 lakh cases pending. And at the Supreme Court level, we have 70,000 cases pending, and this is the highest ever. And yearly, this is just going on increasing by lakhs. Pendency itself is not a problem, if you ask me, because it signals that the society is becoming litigious in the sense that people are aware of their rights. They want to go to the formal court system to resolve their disputes. They are not, we are not at an age where there is a dispute, then people just fight with each other or kill each other to resolve. Thankfully, when there is a dispute, people still have enough faith in the judiciary to go to it to resolve them. So pendency is good, that a lot of cases are coming into the judiciary. Pendency is indicative of that, right? That a lot of cases are coming into the judiciary, which is a that is where judicial capacity question comes into picture. And that is directly related to judicial vacancy. How many judges are there in the country right now to deal with the kind of inflow of cases? So the supply of cases are there, but do we have enough capacity internally to deal with those cases? This massive pendency coupled with delay indicates that we actually don't have the capacity to deal with cases. Now, as it is, we don't have capacity in terms of the number of judges, and then you add administrative burden on the same judges. Obviously, that individual is going to crumble, right? This is one key problem that needs to be addressed for the judiciaries to start functioning better. How do we ensure that the judges are in charge of only deciding cases? How do we eliminate and remove the additional responsibilities that is currently vested with them? That is something that we need to seriously think about on the policy side. So far, the judges have come to be in charge of both judicial and administrative responsibility, because independence of the judiciary is something that the judiciary very staunchly protects and cherishes. And we all can understand why, right? If a judge is not independent, if a judge is influenced by the executive or the party or any other external influence, then it directly affects the image of the judiciary, and it results in the ordinary public losing faith in the judiciary to be able to deliver justice. So lack of biasness and independence is an integral component of the word justice itself. Because of this pressure of showing that they are independent, judges did not want to interact with anyone outside the system. When it came to listing of cases, when it came to court infrastructure, when it came to budgeting, when it came to staffing, everything the cohort of judges were like, we have to do it ourselves, because as soon as there is somebody external to the system handling all this, there is a likelihood of bias. For instance, let me give you a simple example, right? Listing of cases. Listing of cases is a technical function. It is about how many cases need to be listed on a daily basis to ensure that the cases get resolved quicker. And this listing has to happen on multiple parameters, right? But what case comes first? What category of cases should be given importance? What are urgent set of cases that the judge needs to deal with? Now, all of this, because it also takes certain subjective assessment, because a judge sitting over there might think that bail petitions need to be taken up today as opposed to matrimonial disputes. Now, that is a call that the judge is taking based on his or her experience in dealing with these cases, or his or her assessment of what is important and what is not. Now, if this role is outsourced, say to a management expert, a court manager who is not well versed with the judicial side of things. Now, if that person is not entirely honest and is amenable to external influence, either through monetary corruption or otherwise, he or she may list cases based on a party's telling or based on what is suitable for the government. Perhaps the government wants to push certain cases, wants to delay certain cases. So based on that, if the cases get listed or do not get listed before the judge, then the independence of the judiciary, the non-biasness of the judiciary comes into question, right? To prevent this sort of questioning, all the power has come to be vested with the judge herself. And this has ensured that there is extreme inefficiency, because there is only so much that a person can do. On a daily basis, they need to hear 100 odd cases. Imagine sitting over there from morning 10 o'clock till 5 o'clock. They are listening to hundreds of problems, and each problem comes to them for 2 minutes, 3 minutes at a time. For each of that, they have to pay attention give a decision for that specific day and move on to the next. After discharging all these responsibilities, they come back to their chamber and look at how the listing has to be done, which staff has asked for leave, how much salary needs to be paid. This concentration of power and responsibility has resulted in the entire judicial administration being very inefficient. Um, we have conducted multiple studies. We have spoken to the staff of the judiciary. We have spoken to the judges, and they have identified that there is a real need now to de-link judicial function from administrative function. There is a need for separate administrative cadre for the judiciary. It is surprising that that is still not there. Even for the executive, you have Indian Administrative Service, then you have your politicians managing the front end. But with the judiciary, everything is done by the judge. That is where the inefficiency lies. What this has resulted in is that there are a lot of archaic processes. For instance, your service of summons, which is essentially where the presence of a case in the court is intimated to the opposite party. You as a petitioner go and file a case. Then the court has to issue notice to the opposite party saying a case has been filed against you. So come and be present in the court and submit what your case is, right? Just this element of service of summons to the opposite party typically takes around 280 days just to deliver. And here we are at an age where, you know, the biggest of parcels are at home delivered in a matter of day. Today, you click here, you order TV on Amazon, Flipkart, it is delivered to you the next day. So lakhs of worth of rupees of transactions are happening at the click of a button, and delivery is happening within the matter of days. But when it comes to judicial process, it is taking months. Now, this is a sort of inefficiency which is easily manageable with technology, with the right kind of management processes. But there is no one inside the system who has the power to do this or the time to do this. These are what you see on the slide now are a few of the issues that persist because of the lack of administrative dedicated administrative cadre. So there is staff vacancy. We talk about judicial vacancy, but nobody really talks about the vacancy in the administration, and staff vacancy is in the range of 30 to 40% in all the courts that we have studied. So if you have only 10 people doing work of around 40, 50, then obviously the case is going to languish. And that is not because only the judge does not have the capacity, but because the system does not have the capacity to deal with that workload. Then, as I said, you have archaic processes, and there is no process re-engineering. Whatever was the system almost 50 to 60 years ago, or even when the Britishers left our country, the process that was followed then is followed today. There has been no re-engineering of processes at a foundational level. It is all at a very surface level. Then court has workplace issues. One thing that often gets missed out is how court is actually a workplace for judges, for the administrative staff, for the lawyers, right? What are their working conditions? Wherever we have gone, what we have seen is that the workplace, the stations that they work out of, it is poorly lit. There is lack of ventilation. The judges' chambers are not spacious enough for the kind of workload they have. So there are a lot of workplace issues that also need to get ironed out. And this is typically the function of HR in any well-functioning company, right? But even the HR over here is the judge herself. And as I mentioned, there is limited capacity over there. Then there is lack of feedback and grievance redressal. This is a very real issue, right? There is nobody there to give feedback to the court system. Like today, if you have a grievance with Amazon, you will file a complaint and you will ensure that your complaint is addressed. But for something like justice delivery, which is such a key component of a civilized society, if you have an issue, you have to deal with it yourself. You have no avenue. For the judicial component of things, where a case is decided against you, you can go to the higher court. But say your case does not get listed for several months, or the bench clerk over there is demanding money from you. Where do you file a complaint? Nobody really knows, because there is no feedback mechanism, there is no grievance redressal authority. Then overall, what we have seen is there is hesitance to rely on technology and data. This is something very typical of the judiciary and the judges. There is resistance to new age technology, and that is because whenever technology has been introduced, it hasn't really gone hand to hand with the kind of training that is given, or there is no hand holding through the process. This has resulted in a lot of inefficiency because of technology. What is happening in several courts now is data is getting entered onto the computer systems, and physical case files are also being managed. So that administrative staff has now multiple responsibilities, one with respect to ensuring that there is data available online and also maintaining physical files. So this reliance on data and technology hasn't really resulted in efficient processes. That is another big concern within the judiciary. As I said, these problems persist because, one, there is concentration of powers and responsibility in the judge. There are multiple committees, as I mentioned, but there is no change management framework, as is the case with any well-functioning company, right? There are change management frameworks, if you think of it from a management perspective. But no such expertise is there in the judiciary to deal with these changes that are continuously happening. And there is also no systems thinking approach. For instance, what is happening in one high court is not really known to the other high court, or what is happening in the Supreme Court does not percolate to the rest of the courts. Each of them are on their own paths towards change. So there is a lot of disaggregated changes that we see across the judiciary. The judiciary as a system is not really dealing with a problem in a manner that there is consistency, in a manner that we can see some change at the end of a few years. Then there is lack of expertise, and this is to do with how the power is concentrated in judges, right? There is no management expert dealing with management problems. There is no architectural expert dealing with infrastructure problems. There is no systems thinking, there is no design thinking. Everything is concentrated with the judge, and the judge may or may not have expertise in dealing with these issues. But overall, the biggest problem is that the judiciary still functions like it is, like it belongs to the British Raj. Very little has changed in terms of ethos. Justice is not seen as a service. It is still seen as something that is given out to people in the form of a charity, right? Nobody is really concerned about the kind of experience a litigant has when he or she enters the court. Me as a lawyer, I get intimidated when I entered the court system, and I can only imagine how perhaps a poor person from a remote village might feel when they enter the court complex. It is very intimidating, and you don't know where to go, you don't know who to speak to, you don't know whether your case will be heard. Then there are language barriers. There is no information system that helps each and every citizen of the country to be comfortable while accessing the court system. And contrast that with the Amazons of the world. Like, there is so much investment to ensure that your experience while ordering online is good, right? Now you get your information in vernacular language. There is so much of assistance provided just on that digital platform. And then your delivery persons are trained to behave well with you. So that service is seen as something which is precious, and people want to make it a good experience for you. But that is not the case with the judiciary. It is almost like you go there with a begging bowl, and if you get a good outcome, then you're lucky. But nobody at the back end is making any conscious effort to ensure that you as a litigant get justice as a matter of right. And we are in the 75th year of independence, right? Justice should be your right that you can access. Unfortunately, we are far away from that today. Broadly, when it comes to policy making for the judiciary, the way we have approached it, I know I'm running short of time, so I'll sort of skim through these slides.
I have a request to the participants. Would you like her to stick to the 12 o'clock time work, or would you like her to explain it in proper detail? Because this awareness about the need for legal reforms is a big need in our country today. So can you all please write in the chat, would you all like her to continue in detail, or would you like her to stick to the timelines? Deepika, please get into detail.
Sure. All right.
Yeah.
Okay. Thanks, Shivani. All right. So what I was saying was, when it comes to justice as a service, there is no real dedicated effort which is being taken by the system to ensure that your interaction with the system, your experience while seeking justice, is as comfortable as possible. Of course, on the criminal side, it is very different, right? You are an accused, or you're a witness, or you're one of the complainants. There, the things become very different. But at least on the civil cases side of things, where there is just a civil dispute, there is a contractual dispute, or there is a property matter, in any civilized society, you have those disputes. In fact, having disputes is a mark of civilization. That means that there are more contracts, there is a lot of economic activity, and increase in economic activity always results in more disputes. So having disputes, as I mentioned earlier, in itself is not a problem. But the society and the country overall needs to have a robust dispute resolution system to ensure that those disputes, as and when they arise, are getting resolved quickly, immediately, so that the parties can move on with their lives, so that more economic activity gets generated, which is good for the society, good for the country. But what is happening with the kind of justice delivery system that we have is that all those disputes are getting stuck within the system. What that means is that money is getting stuck in the system. All those contracts are not getting discharged. Lakhs of crores of rupees worth of projects are stuck in our court system because it does not have the capacity to deal with those disputes, to deliver justice. And this is a massive problem for a country like ours, which is trying to move on from being this developed to developing for few decades now. So what the government does is important, but equally right now we are at a phase where judicial reforms has become critical for us as a country to actually achieve economic progress. This has obviously come to be even more, it has come to be exacerbated with the COVID related lockdown. The last 2 years, the filings have dipped to an extent because, well, people are not really going to courts and filing cases. But equally, because the courts have been very, they have hardly been functional, the pendency has risen by 20%, right? And this is problematic. So we are at a stage, because of multiple factors, because of economic slowdown, because of COVID related grievances that we have all had, that to progress from this stage to the next as a nation, we need to fix our judiciary. Without that, things are going to collapse. In fact, one of the key indicators of economy, the way in which economy is perceived by external players, is the EODB rankings, right? That is released by the World Bank, which is ease of doing business rankings. Your ease of doing business rankings, as released by the World Bank, is relied on heavily by people who invest in your country. So if you want to attract FDI, then your EODB rankings should be really good. Now, in our country, while we are making decent progress in terms of improving the EODB ranking overall, the one parameter where we have consistently failed to improve, and in fact we are deteriorating, is the parameter on enforcement of contracts. Enforcement of contracts is directly linked with the capacity that the justice delivery system has in dealing with disputes. Imagine as a foreign investor, you come here, you invest billions of dollars. If there is any dispute, it enters the court system here, it gets stuck over there for 10 years. No foreign investor wants to be stuck in that situation. So the status of our justice delivery system is actually directly affecting the amount of money coming into our country. Hence, there is an urgent need to reform our justice delivery systems. Coming back to this slide, as I mentioned, there are a few principles that we cannot compromise upon when we deal with the judiciary. Independence of the judiciary is extremely important. While I have said that independence as a principle has resulted in inefficiency on the administrative side, equally, I say that independence of the judiciary is extremely critical for our democracy itself to function. There can be no situation where the executive, the government is influencing how the judiciary functions. That is the death of democracy. So independence of the judiciary is critical, and this is both in its administrative side and judicial side. Then there needs to be transparency. Transparency in the judiciary is critical again, as we can imagine. It is not enough to just say the ultimate decision is in your favor, but if it is in your favor, it means it is against some other person, and that other person needs to feel that justice has been done. Otherwise, he will go and challenge, right? To comply with an order, you need to have faith in the system which has given that order. And for that, transparency is extremely critical in both the processes and services. Transparency at each stage, so right from the filing to listing to delivery of summons to hearing, arguments, evidence stage, and the final decision. At each of these stages in the life cycle of a case, transparency is critical. And it is also critical on the administrative side. Who is getting appointed as a judge? Who is assisting the judge? What sort of tenders are being, tenders are being successful when it comes to court administration? Who is building the court complex? Do they have any case pending in the court themselves? So these form of complex questions, if they are not being answered in the favor of the judiciary, will essentially reduce the faith in the judiciary itself. So transparency, both in its judicial and administrative functioning, is critical for the judiciary. Then efficiency. It is not just enough for you to have a decision in your favor, but how long did it take for you to get that favorable order? Or even an order against you. See, as a reasonable individual, if you go to an authority and you know that the authority has done a thorough inspection of your dispute, has given a valid decision in a timely manner, even if it is against me, I will comply with it, right? As a reasonable individual, I'll do that. But if, say, at the end of 10 years, I have spent lakhs of rupees and the decision is against me, will I comply with that order? Perhaps not, right? So efficiency is critical to ensure that people are incentivized to comply with the orders of the judiciary. Then you have inclusivity. Inclusivity within the courts is essential, especially for the day and age that we are in. It cannot be that the court as systems are accessible only by able-bodied persons. I may be a blind person, I may be handicapped. That does not mean that I cannot go and access justice in the court system. I'm paying tax, I'm a law-abiding citizen, so I should be able to access the court system. But today, if you go to any of our court complexes, it is extremely difficult, even as an able-bodied person, to navigate through the court complex, let alone a person with any form of handicap. So inclusivity in infrastructure is important, and inclusivity on the bench. Right now, unfortunately, the representation of women in the judiciary is abysmal. Last month, we celebrated Justice Nagaratna's elevation to the Supreme Court. You may have all read in newspapers. She is likely to be the first female CJI of the country. And this is 75 years after independence, which is quite shameful, right? You would have expected for everything that we talk about, gender equality, all of that, that female representation would be quite all right, at least on the bench. By the bench, I mean amongst the judges. But in the higher judiciary, which is the High Court and the Supreme Court, the representation of women is 11%. In the district judiciary, it is 27 to 28%. So very few female judges are actually there as part of the system. And as a female litigant, if I were to go today, that doesn't give me enough confidence that the judiciary is going to do a good job of any of these gender sensitive matters. Of course, the popular narrative right now is that, the judiciary is always favoring the women, the police are always favoring the women, but statistics tell you entirely different story. The conviction rate in gender sensitive cases is abysmal. Most of the cases are withdrawn, be it rape cases or divorce cases, domestic violence cases. Most of the cases are withdrawn. And wherever there is a decision, it is usually acquittal rather than conviction. So if you go purely by data, it is still a very much male dominated patriarchal system that we have in the judiciary. So lack of gender diversity on the bench is a great concern. That also needs to be addressed. Then the last principle is accountability. There needs to be accountability amongst all stakeholders, not just the judges. So you cannot just point fingers at the judge and say that, he is not deciding properly. He is taking a lot of time. He is granting a lot of adjournments. The problem lies equally with the lawyers. Why are lawyers seeking as much adjournment? Equally with the public prosecutor. Is the public prosecutor well prepared to represent your criminal case before the court? And most of all, the problem also lies with the litigant. What is the purpose for which the litigant is in the court system? Nowadays, at least in my experience, what I'm seeing is a lot of them are there to game the system, not really to seek justice. They want to punish the other person through the process, drag the case for multiple years, and ensure that that in itself is a form of punishment to the other person. File false cases on multiple accounts, be it contract, property, whatever else. So the law itself is being misused by ordinary litigants. I'm not saying all of them do, of course not. There are genuine grievances, but a significant chunk of them are also there to game the system. Unless we have accountability amongst all the players, the judges, the litigants, the lawyers, the administrative staff, the system is not going to function well. You cannot just hold the judge accountable and everyone else goes about doing their thing as per their interests. That is not the idea of a fair and just justice delivery system. So all these principles coming together is critical for the judiciary to be able to discharge its constitutional responsibility of providing access to justice for all. Independence, transparency, efficiency, inclusivity, and accountability. These are principles that need to work hand in hand and should be visible at each and every stage of the functioning of the courts. And all of these are equally applicable, as I said, to all actors within the system, not just the judges. Right. So far, the approach that has been taken to improve the functioning of the judiciary has been two-pronged. One is increase the capacity of the judiciary. As I mentioned, there are lakhs of cases entering the system. So the obvious way of dealing with it is increasing the capacity within the judiciary. This is in the form of appointing more judges, training the judges in a better way, technology-driven changes, streamlining the processes to whatever extent possible, and appointment of court managers. Court managers were something who were of a set of people who were appointed a few years ago, right, in a few courts. But of course, it's a different story that experiment did not work well at all. But yeah, one of the things that was done was to increase the capacity of the judiciary. The other strategy that was adopted was to reduce the burden of judiciary. As I mentioned early on, court system, the public court system is a component of the a larger dispute resolution ecosystem. We have alternative dispute resolution mechanisms in the form of arbitration, mediation, lok adalats, now gram nyayalayas, all of whom intend to reduce the burden on the judiciary, while at the same time providing an alternative to effectively resolve your dispute. So the idea is not that we say don't enter the court system because the court is overburdened. The idea is to say that yes, the court is overburdened, don't enter there, but go here. This is the alternative that exists where you can actually resolve your disputes quicker, in a more efficient manner. With arbitration, mediation, and conciliation, they have been in existence for a few decades now. However, the success of this model is not something that that has been very satisfactory. Not many people still opt for arbitration and mediation because there is some issue when it comes to enforcement of those awards. There is hesitance in terms of mindset itself. So it hasn't been as popular and as successful in reducing the burden on the judiciary. But a recent entrant into this has been online dispute resolution. Now ODR is where technology is used to resolve disputes through arbitration, mediation, and lok adalats. I don't want to spend too much time on it, but broadly to say that now there are private ODR service providers who will be able to resolve your disputes in a significantly lesser time and cost. That is something that has been adopted by Niti Aayog recently as a policy, and all the government departments have also supported the idea of ODR, and they themselves are on the path of integrating ODR for government litigation. I was a part of the committee which drafted the ODR policy at Niti Aayog, and I can tell you that there are steps being taken to mainstream ODR so that it becomes a good alternative to the judiciary. And as an ordinary citizen, you can in fact go to any of these ODR platforms and get your dispute resolved. And it is as good as you buying something online. So that way, I think we are headed in the right direction over there. But again, when it comes to court, we have something called e-courts project, as I mentioned, and I'm part of the Supreme Court e-committee, which is drafting this vision statement for phase 3 of the project. And in phase 3, we are looking at nuts and bolts of the system and seeing how things can be improved at a foundational level through technology to ensure that there is greater efficiency at the end of this technology. So technology as a means towards efficiency and not an end in itself. So that is also something that is happening in parallel. With both of these happening in parallel, I do see that in a decade or so, the entire system that we are used to now will undergo a major overhaul. And that is, however, it is a continuous journey, right? What is happening right now is it is very much dependent on the Chief Justice, who is Chief Justice of India, who's there in the Supreme Court, or Chief Justices of the High Courts, because High Courts have to take initiatives at their level. In a few high courts, there are enthusiastic CJs, and in a few others, there aren't. So it has come to be very disaggregated. But if there is a framework which takes into account long-term vision-driven policy making, as we call it, where we say that, okay, we set a target that at the end of 2030, this is where we want the judiciary to be. And based on that vision, we work backwards to identify what the milestones should be in each year. Then the judiciary will consistently make improvement to ensure that access to justice becomes a reality for all. Otherwise, we will continue on the path of disaggregated policy making, which might not really benefit anyone in the long run. So to close, what I'll say is that while we are taking a few concrete measures, be it in the form of ODR or in the form of e-courts project, or in the form of what Justice Ramana has recently proposed, which is create an infrastructure corporation looking at judicial infrastructure. So long-term dedicated bodies looking at judiciary's problems are critical to ensure that we resolve it on a consistent basis, on a continuous basis. But apart from these few examples, I don't see much change happening on other fronts. And hence what I propose is that we immediately, in consultation with the judiciary, of course, because policy making for the judiciary cannot happen outside the judiciary. The intention and the will has to come for it from within. What we are trying to tell the judiciary as we speak is that these are the various components that need to be put in place to ensure that there is vision-driven policy making. First is identification of the vision at the end of 10 years, 20 years, 30 years. And then we look at judiciary as an interconnected system where, it is not like a monolith. It is not like Supreme Court, High Court, and District Court are like one solid mass. There are so many complications at each level. So it needs to be seen as an interconnected system within the judiciary and outside, because this system is then connected with prisons. It is connected with police. It is connected with investigative authorities. It is connected with legal aid. So all these systems need to work with each other for there to be an overall improvement in justice delivery. So how do we envisage and think for judiciary as an interconnected system? Third is there is a need for expert-driven policy making and solutions. I mentioned early on that judiciary judiciary is in the shape it is because the judges have been experts of all kinds. That needs to change. You need to bring in real expertise in different domains for there to be proper solutions and long-term solutions to the problems that the judiciary is facing. Then we look at technology as a means and not an end. This is something I've spoken about. Then you need to have change management frameworks. So it is not just necessary to introduce a change and just leave it at that. You also need to see how this change is affecting different actors within the system. For some of them, it may be beneficial. For some of them, it may not be. How do we ensure that everyone is taken along the journey of reform such that the judges and the staff equally benefit as well as the litigants and lawyers? Change management frameworks is something that hasn't been thought about seriously in major institutions in the country, but that needs to happen now. Then we need to have participatory decision making with feedback loops. I told you how there is no grievance redressal mechanism. There is no feedback mechanism. That needs to be put in place so that the system keeps on improving on a continuous basis. It remains agile. It is not that today we all sit together, bring some changes, and the next we look at it is 10 years later when something again drastically goes wrong. That cannot be how the system functions. There needs to be continuous improvement. Then there needs to be continuous evaluation and course correction. This is again at a policy level. We need to ensure that whatever change we bring in, it is evaluated periodically. And if something doesn't work, we course correct. If we bring in this kind of thinking into judicial policy making, I do see that there will be long-term changes. And access to justice for all may become a reality sooner rather than later. And with that, I'll stop. Thank you.
Thank you, Deepika ma'am. It was so insightful. The talk was so insightful and we learned so much. Quickly, I would ask the audience to take a quick poll. It's for us to curate better topics for you and to understand, have a short feedback from you. Meanwhile, while you answer the polls, would like to talk about the fundraisers that we have on Vishwa.org. So Vishwa.org, as you know, is the change maker. It's the platform for all the change makers. It's a crowdsourcing and a crowdfunding platform. We have a fundraiser from Parampara who is working for the artists, who are supporting the artists who got affected due to pandemic. The COVID-19 pandemic has had a severe impact on all artists across art forms, but none have been impacted more than the performance artists. With COVID restrictions and social distancing norms, performance art and its artists have been left with no means to livelihood due to a lack of platforms or events where they can perform. Parampara has created a dance competition called PDL, and they are rewarding these artists through that. Each and every participants are going to get rewarded. We request you to fund the sponsor the rewards to the artists here. The next fundraiser that we have is for Baal Vikash Educational Society for Disabled Children. Surveys show that nearly 2 out of every 100 children in India suffer from some form of mental disability. Children with such disorder find it extremely difficult to communicate with others and function in society, and as a result, need utmost support and care during their development journey. For 14 years, Baal Vikash Education Society, Hyderabad, has helped many such children and parents of these children who needed mental growth and encouragement. They are raising funds to help them pay salaries of their incredibly committed, devoted faculty of teachers and counselors. Towards the end, we will play a video where you can actually see how connected these children are with these faculties, and if these faculties leave, how it's going to impact them. The next fundraiser that we have is for Totapalli Jilla Parishad High School, which is raising funds to build toilets for its female students. We all know that toilets are very crucial for the hygienic improvements of people, particularly of children. Totapalli Jilla Parishad High School is located in the Kalwa Kurti Mandal of Nagar Kurnool district. The strength of the school amounts to 226 students, of which 128 are girls and 98 are boys. The girl children are usually shy, and due to absence of functional or unusable toilets in their school, these girls are dropping out of schools. And it's the need of the hour for these students to create a hygienic and healthy environment for children in school, for ensuring a promising future. Hence, these basic facilities needs to be provided in girls' toilets in this school. We request you to donate as much as you can, because every contribution counts. Your small gesture can go a long way. By donating or by supporting the cause, we would invite you to be an esteemed member of Vishwa Community of Change. You can also share the fundraisers with your friends and family. I'd like to move, you have the links to all of these fundraisers in the chat box. Please help these kids, please help these children. Let not their dreams die because of any disability or any issues in their school or any facilities that they're not able to. It's not their fault. Please donate to these children and help them support their dreams. We'll take question answers now from the chat box. And if you want to ask questions directly to Deepika ma'am, you can use the raise hand options, and we would make you ask the questions directly live to her. There is an individual, Mr. Rakesh Mishra, who has been, I think, talking about a lot of issues and stating some solutions, if I understand. If you want to ask any particular questions live from Deepika ma'am, you can use the raise hand option. Mr. Govardhan Rao says, problems are known and solutions are known, but there is resistance within the judiciary for reforms. What are your specific policy measures to overcome the problem, ma'am?
Right. And you're right that solutions are also known. As I said, these are not issues that only the judiciary faces. Any massive company is equally embroiled in all these, supply and demand issues and management issues. You're right in saying that there is resistance from within. However, this resistance is not unfounded. There are genuine concerns, say, for instance, at the staff level. And one of the examples I gave was that whenever a reform was introduced, they were not really taken into confidence. and there were no proper trainings that were given to them to adopt to those changes, be it in terms of technology or be it in terms of introducing any new official. For instance, with say court manager, I mentioned that court managers were introduced as a separate designation in the district court and in the high court. However, that experiment has completely failed because while introducing that particular designation, no thought was put into identifying where that particular person will fit and what his or her exact role will be. Will they be looking at reporting directly to the judge, or will they be assisting the judge in this specific manner? If that is the case, then what will happen to the rest of the staff? For instance, until the court manager designation came into picture, the registrars and shirastedars used to discharge that function of listing of cases, managing the court, etc. But now you've brought in court manager without really looking at what will happen to the rest of the designations, which is why I said, okay, you can introduce change, but there needs to be a proper change management framework which looks at how that change is affecting everyone. Because that hasn't been done in the context of judiciary, there is resistance for any and every change now. Hence, the way anyone thinks about changes itself needs to be a little different from what it has been previously.